Good morning, viewers. Welcome to this law lecture series. Today's topic is oral examination of witnesses by police. Very soon you will have the Hindi version of this lecture also. Three things. First, what is the basic function of the police? One, maintenance of law and order. Second, investigation. What is investigation? Collection of evidence, including oral examination of persons supposed to be acquainted with the facts and circumstances of the case. Now, how this oral examination is to be conducted? Procedure is laid down in section 161. That is the basic section. Two allied sections are 162 and 163. So we have to discuss three sections: 161, 162 and 163 of the Code of Criminal Procedure. Now let us examine these sections. Here is the structural analysis of section 161. Oral examination by I.O. I.O. here means investigating officer, or R.O. R.O. here means requisitioned police officer, a police officer to whom request has been made by the I.O. to hold oral examination. So who is to conduct oral examination? The investigating officer or any other police officer requested by him. Who is to be orally examined? Look here, any person supposed to be acquainted with the facts and circumstances of the case is to be orally examined. Whether this expression includes an accused person also? Can oral examination may be held of an accused person also? This point was contested in the case of Nandini Satpathy versus P.L. Dani. Whether the person supposed to be acquainted with the facts and circumstances of the case includes an accused person also? The Supreme Court replied in affirmatively. So oral examination may be conducted of the accused person as well as of any other person supposed to be acquainted with the facts and circumstances of the case. Now, clause 2 of section 161. Suppose I am being orally examined. What's my duty? What's my duty? Clause 2 says, your duty is to answer truly all the questions relating to the case, excepting three questions. I may refuse to answer these questions. Why? See, my objection is that answer to this question may expose me to some criminal charge. Sorry, I can't answer. Secondly, answer to the question may subject me to some penalty or forfeiture. And for that reason, I will not answer this question. Next, clause 3 of section 161. Suppose I am being orally examined and the police officer finds that there are some important matter in what I have told him. So he may record it, he may note it down. Now another question. Can the oral examination be conducted by audio, video, electronic means? Yes, this is an amendment in section 161, clause 3, and it allows oral examination by audio, video, electronic means. Now this is very important. Proviso 2 is very important. It says oral examination is necessarily to be conducted by a women police officer. And if a women police officer is not available, in that case, any other women officer. Male police officer is not to conduct oral examination. In what cases? Look here, these sections. These are the sections of the Indian Penal Code, and they relate to sexual offences against a woman. A woman who has been sexually assaulted or who has suffered attempt thereof under any of these provisions of the IPC is to be orally examined either by a women police officer or, if she is not available, by any other women officer. Now the section 162. My oral examination, if reduced into writing by the investigating officer, well, he can, but he will not ask me to sign the statement. Look here, section 162, clause 1 says the statement is not to be signed by the maker. Second, what use can be made of the statement so recorded? Can some use of this statement be made? Yes, two uses. First, suppose the maker of the statement appears as a prosecution witness, a state witness, and testifies. In that case, his testimony may be contradicted. In that case, his testimony may be contradicted by his statement recorded under section 161. So the first use is to contradict the testimony of the maker if he appears as a prosecution witness. Second use, look here, second use. My statement that has been noted down, reduced into writing, may also be used in re-examination. Now the third section, 163. Very simple. A person not willing to make oral statement is not to be compelled. No inducement, threat, or promise should be employed to extort a statement from him. Let him be a free agent. Secondly, suppose I am eager to make a statement, I am willing to make a statement, don't discourage me, don't caution me, don't dissuade me from making the statement. Let me be a free agent. If I want to make a statement, I should be allowed. If I don't want to make a statement, I should not be compelled. That's all. Thank you very much.